Hello there. With the first changes from the Renters' Rights Act from the 1st of May, now is the time to ask, are you prepared? There's been a lot of noise and plenty of misinformation, so in this video we're covering some of the most common myths to help set the record straight. Let's dive in. Myth number 1. Landlords will no longer be able to evict tenants. This is simply not true. The Act is designed to bring more clarity and consistency to the system, while ensuring landlords still have clear and reliable routes to regain possession when needed. For example, landlords will still be able to evict for rent arrears, although the threshold will increase from 2 to 3 months, with notice periods extending from 2 to 4 weeks. Serious antisocial or criminal behaviour will also be strengthened as mandatory grounds for eviction. So, while the process is evolving, landlords remain firmly in control when it comes to protecting their investment. Myth number 2. Landlords won't be able to gain possession for personal reasons. This isn't the case. Should you, or a close family member, need to move into the property, or if you wish to sell your investment, you will still be able to regain possession. The Act introduces a protected period for tenants, meaning notice can only be served after the first 8 months of a tenancy, with 4 months' notice then required. But ultimately, if you need your property back for a genuine reason, the Act provides a clear route to do so. Myth number 3. Landlords will not be able to increase the rent and there will be a rent cap. This is another common misconception. The Act isn't designed to stop landlords achieving market rent, it's there to ensure increases are fair and transparent. You will still be able to increase the rent once per year in line with market value, using the Section 13 process, with 2 months' notice and supported by local market evidence. So, you remain in control of your rental value, within a clearer and more consistent framework. Myth number 4. Landlords will be forced to accept pets, putting their property at risk. This isn't quite the case. Tenants will have the right to request a pet, and landlords will need to consider those requests reasonably, but you still have control. For example, restrictions within a lease, such as a freeholder not allowing pets, would still apply. Pet insurance cannot be made mandatory, but it can still be recommended as a sensible way to help protect your property and cover any accidental damage. Overall, this is about creating a fairer and more balanced approach, not removing your ability to make decisions based on your property. Myth number 5. Landlords can regain possession and relet immediately after serving notice. Not quite. The Act introduces safeguards to prevent these grounds being misused. If you regain possession to sell, or for an immediate family member to move in, there are restrictions on reletting the property for 12 months. The intention is to ensure these are genuine reasons, not a workaround to remove a tenant and relet at a higher rent. In practice, it simply means being confident in your plans before serving notice. With the right advice, you can choose the correct route and avoid any unnecessary risk. With the Renters' Rights Act now having received royal assent, we have much greater clarity on what's ahead. The changes are being introduced in stages, with the first tenancy reforms from the 1st of May, and further measures to follow. So, while change is coming, there is time to understand what it means and prepare properly. We hope busting these myths has helped address some of your concerns. If you'd like advice tailored to your property or portfolio, speak to our team today or visit our website for more information. Thank you.